demands that this plan is putting on it.
And, I'm sorry, I just want to make sure I understand. And is it conventional for a planning board to require that review that you're describing of this dependent parking to occur and be cleared prior to the issuance of the building permit? Which is how this resolution is written.
I thought it was
No, it's not.
prior to certificate of occupancy.
Yes,
Yes, you know.
It says prior to the issuance of a building permit, the building inspector and/or village planner shall review the plans and certify that the parking being provided by the applicant to
right.
Village Street Market complies with all applicable village code and state building.
Those 12 spots that are needed.
So in other words, they're asking, right, but that's not asking, so that's distinct from the later one that refers to coming in for a site plan amendment. So they're just making, the idea here is to make sure that those spaces exist and that they meet code.
To answer your question, first of all, what I was referring to is the latter part of 15, which says, to the extent that this approval, including the conditions, requires modifications, then prior to the issuance of a certificate of occupancy, the Water Street Market would have to come in. But to answer your question about whether or not this is usual, the answer is no, it's not usual, for two reasons. One, it's not usual that an applicant coming in requires the accommodation of a separate lot that is subject to a site plan. Secondly, when it does, it is usually fairly obvious of whether or not it complies. And if it's obvious that it complies, then there's no reason to have such a provision in here. And in fact, if this board determines that in your determination is that the Water Street Market can accommodate this, then there's no need for those types of provisions. I had suggested that language simply because it was unclear to me how the board was going to be deciding whether or not it was obvious or whether or not you thought that there still needed to be a review, essentially by Brian in this case, as to whether or not that other site plan, because you hadn't gone through that other site plan, whether that other site plan can actually accommodate the demands on it that are being placed by this application. If this board believes that it can, for purposes of parking, which is really the only issue, then you don't need that other sort of trigger for them to come in prior to certificate of occupancy.
If the other site plan is out of compliance in regards to parking, would they be required to come into compliance? Or are those just totally separate issues that don't even come close to each other?
Yeah, it's not a general whether or not the other site plan is in compliance. It's whether or not the other site plan can accommodate the 12 parking spots in this case.
But if I read I'm sorry, if I read the memo correctly from your associate, it said that the question at hand was if the parking that we are considering as a requirement of this site plan on the adjacent property is out of compliance, then this board is not able to approve this application until such dependent parking is made compliant.
And because we can't, as I sit here now, and when I suggested the language, I don't know whether or not it's out of compliance. That assumed that if it's out of compliance, this is what would happen, right? Without anything else. And one other way to deal with it is, since we don't know whether or not it's out of compliance, we can't say it is out of compliance, and because if you said it's out of compliance, then you can't approve it unless, as you do with many things, you say, all right, you have to come into compliance by a certain time. You do that all the time with your conditions, all right? So it's not presently complying, but you have to either before signing of the plans, before building permit, before certificate of occupancy, or at some later date, you have to satisfy this condition, which now will bring you within compliance. So that's what I'm saying is that if it's not compliant and then you end there, well, of course you can't go ahead and approve it. But if you say, if it's not compliant, but you can come into compliance, you can put a condition on it like you do many other things. Or the next step removed is we don't know whether or not it's compliant with these added demands, and therefore, I had suggested that language in 15 is that to the extent that it's not in compliance, which would say be determined by Bryant, then they would need to come in prior to certificate of occupancy just to fix that non-compliance, not to generally deal with a site plan amendment or whether or not Water Street Market was or was not in compliance with other issues, only with respect to this issue. But if it's determined by Bryant that it's not out of compliance, then they don't need to do anything.
Now, Michael and I and Bryant looked at the last site plan that was approved and compared the current parking to the parking that's on that plan. And we saw that there was additional parking currently that was not listed on the site plan that is approved, plus the configuration. I think there was some parallel parking in the lower parking lot as opposed to nose-in parking, had been changed, and there had not been any site plan changes that were noted or approved. And based upon that, which I think we all kind of looked at, would that trigger them needing to come use the parking? So that it doesn't...
I couldn't answer that definitively. For instance, I don't know, you'd have to speak to Brian, but I would think that if all something is required is a restriping, I'm not sure that that would require coming back for a site plan amendment.
Okay.
If
Well, no, I'm not talking about a
somebody
site plan amendment. I'm just saying to get into compliance so that there's no...
Well, if, for
later
instance, all it took was restriping of some parking spaces to
And
be
removals
in
of
compliance,
Yeah.
either parallel to head in or the width of parking or whatever, I'm not sure that that would require them to come in for an amendment, Water Street Market, simply because they're restriping in a way, except to the extent if Brian determines that by restriping they've lost 6 parking spaces and they needed the 6 parking spaces, that kind of thing.
Well, I think that it was, and then I'm not saying that they need to get an amendment, but I was, even if they went back into compliance with the previously approved site plan, they would still have more than enough parking based upon the available parking there and the parking that Rich Gottlieb was going to provide as well.
If this board believes that the parking demands that this applicant has said it needs can be accommodated by these other methods that have been put forth by the applicant, Water Street Market as well as Rock and Snow. And this board thinks, either on its own or with advice of Bryant, that that would not bring these other site plan applications out of compliance, then there's no need for any conditions for them to come back in because the determination has already been made. For instance, let's talk about Rock and Snow because I think it's an easier one. The proposal is for Rock and Snow to have available parking at 7 to 11 or something like that, right? And as I understand it, the Rock and Snow site plan anticipates that they wouldn't need that parking during that period of time.
Right.
So if that's the case, and I haven't looked at those site plans, so I can't tell you for sure, but just assuming that that's the case, then you don't need to condition anything with respect to Rock and Snow, right? Because it's clear that the parking demands that this applicant is placing on another property is not going to affect their site plan adversely. And if you were able to make, either on your own or with Brian's advice, that same determination as to Water Street Market, then you don't need any conditions with respect to them coming back for an amended site plan. But if you're unsure, one way to deal with it is to say, to the extent that it's later determined by Brian to be a problem, they would have to come in, and to the extent that it's not a problem, they wouldn't have to come in.
Well, didn't it already get determined that, and I'm just referring to 15, not 13, but didn't it already get determined that it was sufficient parking?
Well-
I guess I'm a little confused why 15 was added. Because I thought, I mean, it is true that they changed the sort of overall time they can use it, but the performance time didn't change. That's when you assessed it. And then I would say, as far as 13 goes, what needs to happen to find out whether anything would have to shift in how the lines are set up, or so that they know, because it sounds like what you're saying is for 13, in terms of code, that whatever spots are going to be available need to fit some kind of code, and it's not all on Water Street that has to, it's just some spots that will be available. What's necessary to just sort of determine if they are or aren't now, so that they know whether they have to make some corrections to those spots, so that we can.
So to answer the question about 13, I think that the board can probably look at the site plan and determine whether or not the spaces are to code. Are they 9 feet by 18 feet or not? And there is some redrawing of some spaces, not very many. So I don't, that's the major issue about 13 is whether we've determined that in general there are enough spaces in Water Street Market to potentially accommodate this additional usage. That is, 12 spaces are generally available. Are the spaces of legal size? They appear to be, but we can look at a portion of the site plan and determine that. If there's anything else that you think that you need to go out into the field and check beforehand, then we can keep this condition in, otherwise we can take it out.
So wait, because the first thing you said is we agreed, so does that mean that 15 is not necessary?
No, I'll get to that.
Okay, I thought that's what you just said.
No, I said generally.
Okay.
The reason that I've been advocating, this is not new, what's new is the wording, but we'll recall going back a ways that up until the first time we looked at the resolution, everybody at the table was under the impression that the applicant had told us when performance times were going to be. Wednesday through Saturday in the evenings and Sunday matinees, or at a different point in time, it was Thursday through Saturday in the evenings and Sunday matinees. So that's what we put in the resolution. It was put there innocently and benignly, and at the table, it turned out not to be so. So the applicant at that point in time made a decision, or had made a decision just prior to that, but that wasn't conveyed to us in a timely manner, that they didn't want restrictions on performance times. Since then, we have received written information from them that indicated that they could be, that there wouldn't be any evening Sunday performances, and there wouldn't be matinees during the week as a regular feature. There was a question about special events, and we can get to that. So, but the point is that in counting cars in the parking lot over the summer, over various months, there were a limited number of times where there weren't enough spaces. There just weren't. The lot was full, or it was nearly full. And so it seemed that there was an agreement, or at least a sense that we were heading towards an agreement, that we could potentially, and the board may say, we don't want to do this, and that's fine if there's a majority who feel that way, that we would identify a time that we would say, okay, whatever the performance times are, we're going to use those times for the first year, and we'll have some mechanism for actually making sure that there are enough spaces. And the only reasons to do that are two. One is to make sure that this theater doesn't negatively impact the already very successful Water Street Market businesses and services that are provided. So, and secondly, that it doesn't result in an extensive amount of parking along an adjacent neighborhood street that's already subject to an excessive amount of parking problems.
I understand. I'm sorry. It's just that I thought that last time when we met, we all chimed in as to whether we felt their new times were reasonable. And I guess in my mind, I thought about parking too, and I think many people brought it up. So I
Okay.
guess I thought that at that last meeting, when we said, this seems fine with these times, by default, we were recognizing that we didn't think it was a problem with parking.
Okay. Okay, well, if that's how a majority of the board feels, then the whole point this evening is to try to go through this resolution and tweak language or strike elements from it so that we can get to a resolution that we can vote on. And if a majority of the board feels that this exercise in collecting data in order to actually know whether there's the impact of the theater and to know over the course of 1 year's set of performances whether or not Water Street Market can actually handle this, if you don't think that data is necessary, then that's fine. That's so that, yeah, I mean, I guess I maybe exercised a little privilege here, and I left that in because I do think that data is important, but
I
I want
just
to.
feel like it's only gonna, it'll hurt Water Street Market if they don't take care of this. I mean, again, my feeling is that the other times they're suggesting they're gonna do things, you know, during the day matinees, we talked about it being busing and other aspects. It's absolutely true. If there's a big event happening at Water Street, they already said they can't plan a big evening event on Water Street at the same time there's a show because it's going to hurt both of them.
Okay.
So I just feel personally that it was kind of covered. And
Okay.
I'm just referring to 15.
No, that's fine.
If I could just follow up on Michael's comment, I think because it's a bigger issue than just this application, it's all the time when you have a draft resolution before you, and that is that who's ever composing it are trying to figure out certain assumptions gleaned from statements, disparate statements many times, taken from various different meetings and put together. And the whole purpose of going through a resolution is not an up or down vote on what's here, but to discuss it, make whatever changes are necessary, additions, deletions, and then, as Michael said, finally vote on something that is going to either pass or fail.
Let's do it.
All right, so, are you okay, Rich? You good?
My battery ran out, we went so long. So he's gonna have to give me those batteries.
Okay, good. All right. Okay, so, well, since we've been talking about these two, why don't we stay on them for a little longer? Let's start with 15. Should we keep this in as worded? Should we modify it, or should we delete it? And you're comfortable.
For deleting.
You're comfortable deleting it. Other folks, we just need them.
Both because I think we've done the diligence to confirm that there is adequate parking in all times that we've measured to date, and I want to go back to the limitations on theater time and days, but I also just think that this process could not yield an accurate determination as to the source of the parking overflow. Even if we tried to say 30 minutes before, 15 minutes after, there's various reasons why people place their car in the parking lot we're discussing. And so even if I thought some version of this process made sense, but because we had concerns, I don't think there's a process that would effectively determine the specific impact of the theater's operations in any of the times that we propose. So I'm in favor of striking 15.
Okay. Others? Dennis?
I feel the same way. It's very hard to know where the parking is coming from.
Okay.
So I would strike it.
All right. John?
Yeah, I'd like to see the data, but I don't think you can tell which car is there for the theater, which car is there for the rail trail, which car is there for shopping at the Water Street Market. So I don't know what
Okay.
they, but I think it would be good to understand it. But I don't think that this is the mechanism to do it, and I don't know what the mechanism would be.
Okay. Rich Steffens, you want to weigh in?
No,
Okay, fair enough. You don't have to. Fine.
I'm happy with the resolution the way it is.
Okay, all right, and I would like to keep it. I don't think
So it's kind of three and three.
I don't think the
3 to
issue
2.
is whether, yeah.
Not in the final vote, but, I mean, your comments
Your
certainly count.
comments count.
Right.
But, I'll just say, I don't think it's a question of identifying which park is doing what there. It's really a question of this application, this project is asking to use off-site parking. And the question that's ambiguous, to me anyway, is, or uncertain, is there enough off-site parking there all the time when this particular project wants to be in use? And the information we have so far is that most of the time, yeah, there is, but sometimes there aren't. And, but I understand where you all are saying, and it sounds like we have.
In that case, I'd say keep it.
Okay, so, but I mean, the question becomes, are you gonna get, so if we